You suffered significant harm and injury as a result of a doctor's carelessness. And now you're deciding whether or not to go ahead and bring a lawsuit against this careless doctor. If you have brought a lawsuit in the past, will it make a difference if you go ahead and sue the doctor? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is maybe yes, and then again, maybe no. Okay, so what am I talking about? You feel in your heart of hearts that your doctor was careless and caused you significant harm and injury. Now, you go to the best attorney you can find, who evaluates your case, who gets your records, and he sends them out to a medical expert, and the medical expert determines that yes, you do in fact have a valid case. The expert has determined that your doctor violated the standard of care, and that as a result of that violation, as a result of that carelessness, you suffered significant harm and injury. Okay, so now during the course of your attorney's evaluation, one of the things he should be asking you is whether you have ever brought a lawsuit before. Now, why is that important? It's important for a couple of reasons. The most important reason is credibility. Now, you might be thinking, what do you mean credibility? What does that have to do with anything? Well, you should know that in these medical malpractice cases, your credibility is everything. Absolutely everything. If you are not credible, if you are hiding something, if you lie about something, if you tell an untruth, which is another way of saying a lie, your credibility is going to be shot. And now you're going to have significant problems when and if you get to trial, trying to convince a jury that you are slightly more likely right than wrong. And if you have a credibility problem, now the jury will take that into account, and there is a possibility that they will turn you away. Why? Because they don't believe you. Okay, so now let's get back to what I was talking about in the title of this video. Let's say you brought a lawsuit in the past. Let's say it was a real estate matter. And now you went ahead and resolved your real estate matter. The case never went to trial. There were no depositions. There was no sworn testimony in the case. And now your attorney asks whether you ever brought a lawsuit before. And you say, yes, I had to go ahead and sue my realtor for X, Y, and Z. Okay, and now your attorney asks a few more detailed questions about that. Now, will that make a difference? The answer is, in all likelihood, no, will not make a difference. However, during the course of your medical malpractice case, the defense attorney, the attorney who represents the doctor whom you have sued, will have an opportunity to question you in a question and answer session, and that's called a deposition. In pre-COVID times, that would typically take place in your attorney's conference room. Nowadays, this mostly takes place on a Zoom video call. However, you should be aware that the answers you give in response to those questions represent your sworn testimony, and it carries the same exact weight as if you are testifying in court, at trial, in front of a judge and in front of a jury. So don't think for a second that just because you're answering questions in the comfort of your home on a Zoom video call, that means that it doesn't have any real significance. Just the opposite. It has a great deal of significance. Now, during this question and answer session, which, by the way, lawyers also call an examination before trial, the defense attorney is going to ask you whether you have ever brought a lawsuit before. If you say no, knowing full well that the answer is yes, that you had some real estate matter in the past, you have now lied. You have now said something that is not true. Now, I guarantee you that the defense attorney, after your deposition is over, is going to do detailed research to determine whether or not that statement is in fact true. They're going to do a database search to see whether you have ever brought a lawsuit before. And if it turns out that you have brought a lawsuit before, and now in your testimony you say, no, of course not, I have not brought a lawsuit before. Now, my friend, you have created a significant credibility problem for you and your case. And you might be saying, wait a second, what does my credibility about this prior lawsuit, whether I brought one or not, have to do with the facts of your case? And the answer is absolutely nothing. However, at the end of your trial, the defense attorney is going to raise that issue with the jury. And he's going to say, ladies and gentlemen, how can you honestly believe what this injured patient is telling you if he couldn't tell the truth about something that had nothing whatsoever to do with this case? I asked him a very simple question during his deposition 6 months earlier, a year earlier. I asked him whether he ever brought a lawsuit before. And you know what he said? Here's his testimony. He said, no, I have never brought a lawsuit before. And now he comes before you and he asks you and he wants you to believe what he's telling you about this particular case and about the facts involving this particular doctor. And now he's going to make you, the injured patient, out as a liar. That's a problem. So let's turn this around. Let's say you were involved in a car accident and as a result you suffered a broken arm and you brought a lawsuit against the careless driver who caused your accident. Now, that particular case went through the discovery process, and you also had to give testimony in a pretrial deposition, an examination before trial. Now, you have given testimony, sworn testimony in that case. Can the defense obtain that testimony to see whether or not there's something in there that they can use against you in your malpractice case? The answer is yes, they can. And now the defense will ask you the same exact question. Mr. Jones, have you ever brought a lawsuit before? Have you ever testified before? And the proper response is, yes, I have. Yes, I did give testimony. Terrific. Now, why is that significant? It's significant because all you're doing is acknowledging that you did in fact bring a lawsuit. You are acknowledging that you did in fact give testimony. And now what will happen after your deposition is over, the defense lawyer is going to ask your attorney for copies of the transcript as well as the pleadings in that case. So what are pleadings? Pleadings are the documents that are used to start a lawsuit. Now, in addition to that, they will want to see the detailed allegations you made in terms of what injuries you suffered. Why would they do that? Because they want to know whether you claimed similar injuries in that case compared to the ones you are claiming in this case, in this medical malpractice action. If they are similar, the defense might change their strategy. They might change their defense. They might argue that the problems you're having now are simply an exacerbation of the injuries you suffered in that car accident. They might argue something totally different, or that they are related. It's all dependent upon what occurred in that prior case. Now, they will also get that testimony, the pretrial testimony, to see what you said under oath about the extent of your injuries, as well as what actually occurred to you, and what limitations and disabilities you had in that particular injury case. Why would they do that? Because they want to make sure that you are not contradicting yourself. They want to make sure that the injuries you are claiming now don't overlap with the injuries that you had before. Because they may turn around and say, ladies and gentlemen, even if the doctor screwed up in this case, don't blame us. The injuries that Mr. Jones is claiming occurred from this doctor, no, that happened in this car accident. That's where the injury occurred. Don't blame us for what occurred there. It's critically important that you discuss this with your attorney. Why? Because it may in fact matter whether or not you gave testimony in the past, whether or not you brought a lawsuit in the past. Does it have anything to do with the facts of this particular case? In almost every instance, the answer is no, but it has everything to do with credibility. So why do I share this quick information with you? I share it with you because I have a few minutes to spare while my wife is picking seashells on the beach, and I wanted to open your eyes to help you understand how these types of cases work in New York. You know, I recognize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.